Hello and welcome to Fiddling with Trademarks with Travis Richins. Thanks so much for being here. Today we're going to talk about some trademark law with Travis. Travis, so good to see you. Thanks for being here.
Glad to be here. Thanks for having me.
So you have kind of a unique, musician and former orchestra teacher background. How has this creative experience shaped your approach to intellectual property, especially in working with small businesses and startups?
I think the experience teaching orchestra and working with junior high students. Now, I'm not comparing business owners to junior high students. I think they're a lot easier to work with, but teaching gives you, you have to have a set of soft skills. It helps you to get along with people, to kind of communicate things. Trademarks is a lot of teaching. A lot of startups, they're maybe new to the area. And so you're trying to, it's not a super complicated area of law, but there are wrinkles that people don't know.
Mm-hmm.
And so having that teaching background, and I love to teach. So I love to teach music and I love to teach trademarks and explain those concepts in, breaking down legal concepts in ways that like resonate with people in business or just people in their ordinary lives. I think that's helped. As far as like creativity, I'm not in the business of helping people come up with their brands, their brand names, that sort of thing. But it does, that creative background does give me a sense of like, okay, can we approach this legal ise in maybe a different way, thinking
Right.
a little bit outside the box. So I think there's a little bit of that. And then just being a business owner myself. So, I've got a solo law firm and I'm running my own solo firm. So I sympathize with business owners that way.
The creative aspect is definitely, like you said, you're not in the business of creating brands,
Right.
But I do think like that having that creative outlet or that creative experience definitely helps in business. I've felt that myself, and I've talked to other people who feel that way too.
Oh yeah, and I think it just humanizes you a little bit.
Very good point.
Before I went to law school, lawyers were intimidating to me. I don't know how intimidating they are to your typical business owner, but I think when they say, "Oh, you're a musician," that's even just something to break the ice, something to talk about. Either because they are musicians themselves. There's a lot of people who like to connect and talk about that, and we'll get sidetracked. It's like, "Hey, let's just talk music for a bit," or it's just, okay, well, you've got a human side too, not just a lawyer.
Yeah, it is a great icebreaker. It's very good. I play guitar, got one behind me. I play too. So like, yeah, it is. It's really like, especially when you connect with people who also either play or just love music, it definitely connects. Do you still teach at all?
Yeah, I still teach. So I run my law office from my home, and I'll go downstairs and I'll teach a lesson and then go back upstairs and work trademarks.
That's awesome.
Yeah, and
That's
I still
really
perform. Really cool. I perform with groups around town, jam sessions and that kind of thing. So people will hear me play and then they'll ask for lessons. And so I love that. And there's a school in Richmond that I'm volunteering at once a week where I teach their orchestra.
I just realized I don't think we've told the audience what you play.
Oh, I play violin. And that's why,
awesome.
Yeah. So it's the Fiddling with Trademarks is why, that's why the name.
It's kind of literal. You're fiddling sometimes and you're doing trademarks.
Fiddling at trademarks. Yeah. Right on the nose. My son said he's like, don't lean too far into the pun, Dad, but
own it.
Yeah. So, like a lot of times people come to me and they're like, I'm like, well, that's very similar to another mark. And they're like, well, if we just add a period here or a dash there or something like that, if we just fiddle with it a little bit, then can we get it through? And the answer is no. So you can't just fiddle with it in order to avoid likelihood of confusion with another brand. It has to be different. That's different from like a URL or a business name.
Right. .net, .com, a dash, a dot, whatever. Yeah. You're right.
You can fiddle with the URL and get it by, but you can't just fiddle with the trademark.
Good to know. So you built a strong reputation in patent litigation before pivoting into trademark protection. What inspired this shift, and how did trademarks play a critical role for your clients in today's business landscape?
I would say less of a shift and more of an outgrowth. So they're both intellectual property, and when I got into doing patents, that just put me in contact with a lot of intellectual property attorneys. So attorneys that I've worked with for many years, they also do trademarks. And that just got me pulled into doing some trademarks, mostly on the TTAP side at first. So I went from litigation to patent litigation to trademark litigation. And then once you get into that, then you start looking at the prosecution side of trademarks. And that's the, helping people register their marks. I joined a Facebook group of trademark attorneys, which, by the way, they're really friendly and helpful. And I would say they're a lot less brutal than some of the guitar Facebook groups I belong to. I really enjoyed these trademark attorneys. And most of them are like, they're doing the registration side. And as I followed them and kind of got more into what they were doing, and then I got connected with some of them, that kind of pulled me into the, helping on the registration side. And what I really like about it is I like litigation, and we can talk about why I like litigation, because I like to win, but I like interacting with individuals one-on-one. And when you're doing trademarks, it's often somebody they have a vision of creating something rather than a dispute they're trying to resolve.
Right.
And so it's fun to be in on that with them, be enthusiastic with them for the brand that they're trying to make, that they're trying to build, and just being a part of that. Like, it's a really positive process, as opposed to in litigation, you've always got some kind of dispute you're trying to resolve.
Yeah, that's a good point. Positive versus kind of like some sort of a negative connotation to litigation. Right. What critical differences between patent protection and trademark protection should small business owners and startups understand, especially when deciding what intellectual property they need to safeguard?
Patents protect inventions, simply put. And there's different types of patents. There's design patents, there's method patents, things like that. So it might be protecting some kind of method that you have, a business method or a device that you've invented. And I think businesses are typically aware when they have something that might be patentable, or at least they know when to ask the question. And I think they can talk to most intellectual property. You can talk to a trademark attorney, and they can help guide you to know, is this something that I need to talk to a patent attorney about? Trademarks protect your brand. And so we're talking about logos, word marks. So when we say the word mark, the name of your business, the logo that you use, and those are the most typical trademarks. You can even trademark like a color or a sound. So there's things like that. Those are less typical. Your most typical trademark is your word mark. And I would say this, almost any business that's conducting business across state lines, they have a federal trademark need in their business. So they should be looking at protecting that. Now, the similarity between trademarks and patents is they're both trying to help you protect your market share. So with a patent, it's trying to give you this exclusive right to this invention, this thing that you've made. In trademarks, it's the exclusive right to use this name or this logo in connection with a specific good or service. So I think trademarks are often referred to as soft IP, but it can be a really powerful way of protecting your turf, right? I mean, at the end of the day, it's protecting market share in some way. And trademark is generally, like, at least the prosecution side is cheaper. It's a little bit more flexible. You don't need to have a patentable invention in order to protect your brand.
Okay.
Right. Those customers can associate, they're like, okay, I know that brand. I associate that brand with quality. If you have some kind of good or service that's easy to replicate by somebody else, at least the thing, right? It may not be so easy for them to replicate the brand or to get the emotional connection that your consumers have with that brand. Right. So a lot of people can make colas, but people have their association with the cola that they like.
Very true.
Or
always a good example, by the way, too. Everyone's got their one that
everybody's got their one. When my oldest child was really young, we I like fixated on these Kelty backpacks. I don't know if you remember those. But I live in Colorado, so. Of course. So everybody owns a Kelty and a Subaru, and
I had a Kelty carrier for my little dude. When we go hiking.
Yeah, I was living on a teacher's salary. I had to dream about that thing for months. You're saving your pennies to buy.
They're not cheap.
Yeah. So you could, people can replicate that kind of device. Now there might be also patent, things involved with a backpack, but there are different brands of backpacks carrying a kid, right? So the way that they, protect their market share is through brand recognition. Like, that name meant a lot to me, right? And your brand means, and then it becomes something that's like, that means hikes with my child, not just, some product. Yeah. So trademarks can get really powerful because your clients develop a really strong emotional connection with the brand.
It also represents back pain, incidentally.
Yeah. No, less back pain. You got to just tighten it on your hips, man.
I don't know. He wouldn't stay still.
Oh, he's wiggling a lot.
He was wiggling a lot.
We've got a picture. I've got a kid on the Kelty on the back, and then our second child in the front, so they were balancing out the weight, hiking up.
Oh my God. Well,
hiking up the mountain with two.
You got a very strong core. That's for sure.
That's right.
Many of your clients are small businesses and startups. What are some of the common challenges that you see when securing trademarks, and how do you kind of guide them along?
So for the really early companies, it's just cost, right? They're looking at, okay, where am I going to spend my money? Do I spend it on IP at all? If I spend it on IP, I did have a recent potential client who did have, a patent need and a trademark need. Which of those are you going to prioritize? Am I going to prioritize marketing first? So for most of them, it's balancing cost and benefit. And, do I have IP that's worth protecting? And then for small business owners like me, it's juggling lots of hats too. Like I'm doing the admin and I'm doing the marketing and I'm doing the actual thing and learning how to delegate that. And I think that's where like hiring a trademark attorney, like I found running my solo firm, like I had to hire people to do certain things that I was trying to do myself, and just start to give up some of that and start pushing it off. And as I started to hire people to do things that they specialize in, which I could do if I spent my time doing it, but it's not the best use of my time, right? It's not the most.
Yeah, it becomes what's your time worth versus what does it cost to have someone else do it? Yeah.
Yeah, and there's great books that like that Buy Back Your Time and those kind of books. And so I start to look at those and I'm like, I've got to outsource this. And so I think that's a common issue that a lot of businesses are facing, like startups. And that's where an IP attorney can help. A trademark attorney can help you do something like, okay, can I go and do this by myself? Yeah, you might be able to. Is it the best use of my time? Maybe not, right? Maybe this is one of those things I shuffle off to somebody who specializes in that thing.
Yeah. Okay.
So one that's interesting me, I haven't looked up the history of this, but I keep meaning to, is Kentucky Fried Chicken, right? Because if you're like, I'm going to name my company Fried Chicken and I'm going to serve fried chicken.
And I'm in Kentucky.
Yeah, and I'm in Kentucky. So Kentucky is a geographic indicator. And if you're just naming and this is actually I didn't mention this in common issues that businesses have, but just naming a very specific trademark issue that they often have is naming their business something that's geographic and generic or descriptive.
That's about the best example you can come up with, Kentucky Fried Chicken.
Yeah, Kentucky Fried Chicken. They have a registered mark and they're very well known. The reason why is if you get, it's called secondary meaning. And that's illegal. They use it as a legal term, but it just means like Kentucky Fried Chicken. When somebody says that to you, you don't think, oh, it's a generic fried chicken place in Kentucky, right? That's not what you think at all.
Nope.
When you think Kentucky Fried Chicken, you think the brand Kentucky Fried Chicken.
100%.
So I don't know if the actual answer is that they acquired secondary meaning, but I think it has to be so if you have a descriptive name, you can still get trademark protection if you get secondary meaning, if you acquire it. And it's a high burden, right? So I try to you want to stay out of that if you can. You want to get into the suggestive, and there's suggestive, arbitrary, and then fanciful above that. So yeah, you have a question about it?
No. I just fanciful. That's the interesting descriptive name for something in trademark law.
My Instagram page is a sorry place right now. It's going to get better, but one of my posts is just keep it fancy. If you make it unrelated, and that's why a lot of strong marks have these made up names, because it's going to be arbitrary or it's going to be fanciful, and if it is, then it's a whole lot easier on its face to get trademark protection.
Okay, cool. Well, thank you. That actually clarifies that quite a bit. I did also want to ask, this is an interesting one. So you're licensed in Texas. You're licensed in Texas and Virginia,
right?
But you offer trademark protection services nationwide. What are the key considerations businesses should know when securing trademark protection across state lines or nationally?
Yeah, there's a few things packed in there. So one is kind of the question of, okay, do you need a lawyer who's licensed in your state to help you with your trademark? The answer is technically no, because trademark law. So we're talking about federal trademark registry. There are state trademark registries, but if you want the best kind of protection you can get in the US is a federal trademark. And if you get registered federal trademark, then that gives you exclusive rights to use your name or logo for the good or service that you provide within the United States. And that's federally preempted area of law, meaning an attorney who's licensed in one state can help somebody in another state register for their trademark. Okay. Now, if it spills over into areas of state law, and that's really more of an issue for your attorney to know, right? It's their legal ethics. I need to know if one of my client's issues starts to spill over into an area of state law where I'm not licensed to practice, and we need to bring in somebody who is, right? So I've got a client in California, and they have a mark that they own in their own name, and they want to expand that mark. It's better for them to own that mark in the name of their business, and they have their business registered in California, right?
Yeah.
So if we're going to get into some areas of you need to register a new business in California, then I would bring in Like now there's some ABA rules that would maybe allow an attorney to go, for me to go do something like that in California, but I'm pretty conservative with that, and I'll get local counsel to do things that they need for in their state.
Okay. Yeah.
So now that's from the attorney's perspective. From the client's perspective, I think you just look for, like, if you want, you just look for a good trademark attorney. They're going to be able to help you with a federal registry if they're a good trademark attorney.
Okay. Got it. And given your background and experience, what advice do you give to startups or small businesses, someone that might be listening, that they're not sure if they should worry about it right away?
So there's a lot of reasons my answer, because, I was like, well, he's selling trademarks, but really they should do it early on. So I've had recently a potential client come to me and they said, there's somebody, we've got this name. They've been using this name for 10 years and they're just in this one state and they hadn't planned on going out of state. And so the attorney that helped them set up their entity said, hey, there's this other company. It's got a similar name to yours, but they're in the East Coast. So I don't think you need to worry about them. So they didn't. So they go into business for 10 years. And now that East Coast company, which happened to have a registered mark in that name, has been expanding across the United States and has moved into their territory in the West, right, into their state. And they're suddenly looking at, oh, maybe I'm infringing on this registered mark that we kind of knew about back then, right? Well, imagine they didn't know about it. So you're starting up your business and you're thinking, I don't need a trademark because I'm a local business. I'm just doing it here.
Yeah, I'm a little guy. Yeah.
Yeah. So in their case, though, like in that case, like at the very least, comprehensive trademark search, it could save you from a very expensive rebrand. So this client, like, they could have spent a few $1,000s on a trademark search, finding a new name and registering a different name 10 years ago. And instead, now they're looking at an $80,000 rebrand.
Wow.
So you save yourself a lot of money just by, it's one of those ounce of prevention kind of things. It's not that expensive to do a trademark search at the outset. I would think almost every startup should, even if you're only local, because you want to know that there's not some national brand or some already registered marks that's going to move into your territory and then cause problems for you later, right? Making you the infringer.
Wow,
so I think it's such an inexpensive IP to get that it's something to look into at the early stages of a company.
I think that makes a lot of sense. And also, just to clarify for anyone listening, I don't know if we've ever said, but by IP, you mean intellectual property, right?
Thanks. Yes.
Yep. Mm-hmm. I meant to say that earlier, and I was like, just in case, because people mind go to like IP addresses and stuff. So I just want to make sure that everyone's on the
intellectual property.
Yeah, intellectual property. All right, good. All right. Well, thank you for joining us on Fiddling with Trademarks with Travis Richins. If you'd like to connect with Travis, you can search him up on LinkedIn. He's active on there. He's also got a website, richinslawfirm.com. Don't forget to like and subscribe to this channel as well. We'd love to have you. Travis, thanks so much for the info, man. That was great.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.